The video contains content that was sourced from XRP's currency market cap news update. Make sure you review the most recent dates. Due to the legal dispute with the SEC, Ripple has also grown. The long-running legal battle that Ripple has been having with the Securities and Exchange Commission is probably going to pick up momentum again since big deadlines are approaching. Undoubtedly, the XRP community will be closely monitoring this particular case in the hopes of resolving the legal issues that have been continuously upsetting the XRP ecosystem. The Securities and Exchange Commission and Ripple are about to have another altercation. Former federal prosecutor James Fan tweeted on March 22nd on X, formerly known as Twitter, revealing the Securities and Exchange Commission's initial short deadline. Ripple will not have a chance to make its counterargument until April 22nd. The Securities and Exchange Commission (SEC) will submit its reply brief by May 6th, the date for submission, after the assignment is finished. These times reflect the most recent changes to the remedial briefing schedule that have been implemented. The opening brief was originally scheduled to be sent to the Securities and Exchange Commission (SEC) on March 13th. It was originally planned for this day. Notwithstanding this, the Commission had asked Judge Analisa Torres to grant a one-week extension, citing good reason as justification. Judge Torres approved the proposal after giving it careful thought. Furthermore, the Securities and Exchange Commission (SEC) asked for an extension of the deadline from April 12th to April 22nd for Ripple to submit its opposing brief. The purpose of this postponement is to provide the defendants enough time to draft a rebuttal that addresses the Commission's brief. This stage, in which the regulator asks the Bitcoin Corporation for particular papers, comes after the discovery phase. The opening brief or remedial briefing stage is a separate procedure that comes first. The Securities and Exchange Commission (SEC) will center its opening brief, which includes institutional sales contracts, on these facts in response to a complaint. The Commission is likely to demand a number of remedies for the purported securities law breach that Ripple has committed. This is an extra topic of interest. Concerning an earlier ruling, Judge Torres, this sentence is incomplete. Please provide more context to complete it. Some of the possible consequences of the remedy briefing include the following. It is expected that the Securities and Exchange Commission (SEC) will file a request for an injunction to stop Ripple from participating in institutional sales that break securities laws, in addition to levying financial penalties. Torres had come to the judgment that the institutional sales made by the Bitcoin company qualified as investment contracts. Conversely, it is quite probable that Ripple will challenge the recommended penalty amount that the Commission has established for the company. It is also possible that Ripple might contend that its global decentralized lending transactions don't fit the requirements for securities classification. Legal expert John Dion had earlier stated that it was very likely that both parties would still need to submit follow-up documents, implying that the remedy briefing would not go as smoothly as it had at first. Even if it is later than that, Deaton went on, he doesn't think a decision will be made until the later part of the summer. The Bitcoin sector is still awaiting the court's official dismissal of the lawsuit as of right now. Nevertheless, there is always the chance that any of the parties will appeal the judgment after it is ultimately rendered. Symbolize the resolution of the lengthy legal battle that has been raging between the U.S. Securities and Exchange Commission and the blockchain startup Ripple. By the deadline of March 22nd, Section 2nd may submit its opening brief in compliance with the revised schedule. As per the latest report on the Ripple CC case, which was submitted by defense counsel James K. Fillon on March 14th, the regulator has until May 6th to respond, and Ripple has until April 22nd to register an objection. To refresh your recollection, XRP sales to institutional customers were deemed to be securities transactions according to a ruling made by Judge Analisa Torres in July of 2023. However, purchases of XRP from regular consumers did not qualify as securities sales. The parties are currently trying to come to an agreement over the amount of damages that Ripple is expected to pay so that you can take into account the stock that is outperforming the market and making investors billions of dollars. This is being done to give you time to think about the stock. It took 13 minutes to successfully allow Pendle integration. The material submitted by Fillon and supplied by the former federal prosecutor at the time supported the SEC's request, which was approved. This supplement serves as support for the request for an extension by presenting the agency's opening brief, the objections raised by the blockchain industry, and the SEC's response. Throughout their briefing, the legal team for the regulatory watchdog emphasized that this was the proper justification in line with federal civil procedure laws. They also emphasized how crucial it is to take precautions with the SEC while deciding on remedies pertaining to discovery. Additionally, to a briefing. Furthermore, the motion claimed that Ripple had already approved this SEC's petition and that Magistrate Judge Sarah Netburn had previously given it permission to postpone the first discovery date. The petition states that Ripple will get 9 more days to provide its opening brief. This is the cause of the situation. Deedon appended a statement shortly after the Securities and Exchange Commission (SEC) filed a motion on March 1 to adjust the briefing schedule, stating that the court had approved the move. The cryptocurrency community is closely monitoring any news reports regarding Ripple CC at this time, searching for any signs that could shed light on the outcome of Ripple and the SEC's legal dispute. It is quite unlikely that a settlement would be achieved before 2026 because the intricate legal battle could lead to appeals. The European Corporate Governance Institute recently released a study that details how the court determined that XRP qualified as a security as it was sold to institutional investors directly, as opposed to being advertised to the general public on an exchange. This year, this decision was taken early. The current attorney's misunderstanding has been exacerbated by having access to this material. In reaction to Ronan's statement, a well-known member of the XRP community, Bill Morgan, made the following statement. The token will never be regarded as a security in and of itself if it is made available as a component of a transaction or plan that is an investment contract for securities, but it may be made available in this way. Morgan went on to remark, the statement was not the most helpful, and some people are still being misled by it even within the XRP community. There are now new deadlines for both parties to file their rectification reports as a result of the protracted legal battle between XRP and the Securities and Exchange Commission, which has attracted a lot of interest in the cryptocurrency space. This new phase of the ongoing conflict assumes significant significance in light of the recent revelations. In response to Ripple's request for an extension of time for remedies related to the SEC, the Securities and Exchange Commission intends to submit its opening brief by March 22nd. By April 22nd, it is expected that Ripple would submit its opposing brief. The Securities and Exchange Commission will then have until May 6th to submit the reply brief. The revised schedule for the remedy briefing has been made public by renowned lawyer James K. Fillon, who has been closely monitoring the Ripple and CC dispute. The most recent changes to the timetable were the cause of the previously stated prolongation. It was found in February.